So, for the next hour or 55 minutes or so, I am going to answer your questions about any pandemic or COVID related legal issues that your associations or your association clients are facing. Um, Anything is fair game, from meetings and conference contracts, cancellations, postponements, cancellation fees, force majeure, and kind of that whole bucket of issues, to issues regarding kind of the return, eventual return to in-person meetings, um, and the um, and the types of legal considerations that come into play with respect to holding in-person meetings and doing them in a way that can be done safely and mitigating potential liability risk to your association, to the eventual return to the workplace, and similar kind of bucket of issues regarding minimizing your association's liability risk for reopening your offices. I get a lot of questions about liability waivers for all of the above. I get a lot of questions on kind of eventual vaccine mandates, whether you can mandate that individuals get vaccinated before they can attend your in-person conferences and or return to your offices. Obviously, it's not an issue that's kind of ripe for discussion quite yet, but hopefully it will be sooner rather than later. And frankly, anything else you want to ask about. I'm throwing those things out there because the issues that I just mentioned tend to be the issues that I get asked the most about when I do sessions like this, of which I've done quite a few in the last year. But feel free, anything's fair game. Just so you know my background and perspective here, I'm an attorney in private practice in Washington, D.C. I've been doing this for 25 years now, all of it in private practice, representing associations and other nonprofits. Started Tenenbaum Law Group with another attorney at the beginning of last year. And we work with about 350 different associations and other nonprofits on a very wide array of legal issues, pretty much almost any legal issue that your associations deal with. I've always had a very kind of broad base of substantive legal expertise. And so almost anything you're going to ask about should be fair game for today. So the things that I'm talking about, we'll talk about, are informed by tons and tons of experience. My colleague Nisha and I have probably worked on at least 600 or maybe even 700 different conferences and meetings at this point over the last year, in terms of cancellations, force majeure terminations, postponements, and all the rest. We've developed quite a bit of insight and knowledge and strategy as a result of all of that, about strategies and tactics that tend to work well and that tend not to work well. Happy to share all of that with you today. And now we are working with a number of associations that are planning in-person meetings for later this year and trying to figure out how to do it safely and how to mitigate their liability risk. So with that as background, I want to open it up to whoever wants to fire away with your questions. And Andrew, I forgot to mention this to you, but if you can help me kind of moderate the questions in the chat box. If any of you want to ask questions verbally, feel free to unmute yourselves and ask me questions. And if you want to post them in the chat feature of the Zoom box, that works well as well. So we need someone to get us started. I know at least one of you has a question.
Well, I'll start then. I'm with the Massachusetts League of Community Health Centers, and we do an annual gala, and we did not hold our gala in June of 20, but in July, with wishful thinking and hoping, we rescheduled it to June of this year. I have a contract that I signed that they did put in now language, and I'm looking at it here, about, in addition, the parties agree that either may terminate this contract if any government agency, including the CDC or any other regional health organization, issues any form of limit on the group events. We have a date in June, and our board has said we do not want to do any in-person meetings before the fall, the earliest. I've reached out to the hotel. I don't know yet what the answer will be, but I don't know if legally, because of the contract that I had in July, and if the governor has not said he's prohibiting any gatherings like that, if there's a way for me to get out of this contract, I mean, is it possible that I could just say, well, postpone it to 2022 and still keep the contract? Or will I be penalized severely for changing it?
Okay, a good question, and it's that type of question we deal with almost every day these days. A few things. So first off, if you wanted to cancel your event altogether and hope to avoid the cancellation fees that are likely contained in the contract, the only way to do it is pursuant to what's called force majeure. And that means that some unforeseen event beyond the control of the parties, like the pandemic, makes it, most of these force majeure provisions say illegal or impossible for you to perform under the contract. In most of the hotel and convention center and other event kind of venue lawyers take the position that the only thing that makes it illegal or impossible is a governmental ban on gatherings of your type and size and in that particular location at that particular time. As you well know, at least since the pandemic began, and things might change with the new administration, but since the pandemic began, there have been no federal bans on holding meetings. There has been guidance and advice from the CDC in particular, but any bans on large gatherings have come at the state and local level. And where you guys are in the Northeast tends to be a region where the governors and mayors have been a bit stricter in limiting, the size and scope of in-person gatherings, and I expect that will continue until the pandemic's in a rearview mirror. But if past is prologue, as things start to improve gradually, I would expect that you'll see kind of a gradual lifting of those limitations, perhaps in terms of size, allowing certain smaller gatherings with proper social distancing and mask wearing and things like that. Prohibiting the larger ones, but perhaps starting to allow some smaller gatherings. We already see that in certain parts of the country. So you obviously have to look first and foremost at that. What is going on in your state and city, and what sort of mandates apply? You absolutely have to look at that first. But then second, you have to look at the language of your force majeure clause. And what you read me is not uncommon. I've seen that before. And at first blush, it seems, oh, this is a great COVID provision, right? It can help get us out of it. But if I heard what you said right, it basically said there has to be a ban on having your meetings, not just some CDC advisory. I do expect under the new administration and the new CDC director that the CDC will get more aggressive on issuing stricter guidance on COVID-related protocols, including meetings and things like that. But for constitutional reasons, it can't be a mandate coming from the feds anyway. And so I'm not sure. This is why I've actually been opposed to a lot of language like that in some of these addenda that have been drafted up by the hotel lawyers and whatnot for some of these rebooks of events. Because on the surface, they seem like they're good, but oftentimes they're written so narrowly that they really don't help you very much. And so that's a potential problem. But that's if you want, so you got to look at those things if you want to try to get out without penalty based on force majeure. If you're gonna, the alternative is just to negotiate with them. So you said, can you push it back another, 12 months? Sure, if it's a negotiation, you can amend the agreement. If whatever both parties agree to, you could amend. If they agree to push it back another year or 6 months or whatever the case is, that absolutely can already work. Can work, but both parties have to agree to it. If anything else they might agree to, that's fine. And frankly, for most of our clients that don't have a good force majeure option, that's what we've been advising them to do, is to focus on a negotiated either postponement or rebook for another year, however you want to look at it. And if you can get them to do it, that's great. Now, you already did it once. So based on our experience, most of the time, these venues are going to push back harder. They're likely not going to just give it to you, especially when we're looking at summer of this year, where most people think that's when things are going to start to turn. They're likely going to dig in the heels a lot more than they did last time. So if you, just speculating, pure speculation, but based on what we've seen, you might have to do something to sweeten the pot. Like you might have to agree to do a multi-year contract where you agree to the subsequent year, or other things like that, or increase the minimum food and beverage spend to hold a nicer event, make it more profitable for them. You might another thing we've seen a lot of our clients do is offer bigger deposit money because they're very, most of the hotels are very in need of cash flow right now. So, prepaying basically some of the fees. These are all ways kind of that you can grease the wheel, sweeten the pot, however you want to look at it, in order to try to get them to agree. But I suspect you'll probably have to do some things like that.
Thank you.
Especially, and they know whether you have a strong force majeure argument or not. And if you don't, you're not going to have as much leverage. So that's why I'm saying you got to create leverage by offering up some other things. If you have a very strong force majeure argument, and I'm not sure that you do, but if you did, then if you're not looking to cancel, maybe you are looking to rebook, but you want a more favorable rebook, you can use that leverage to your advantage. So it's like any negotiation. You got to recognize what leverage you have to use it effectively, and then figure out what end result's going to work well for you guys.
Got it. Thanks.
I'm going to look at it. I'm going to answer a couple related questions, and then we'll kind of move on to some of the other ones. Do you view force majeure clauses in a new contract as unenforceable because the pandemic is no longer unforeseeable? It's a great question. So it really all depends on how the force majeure clause is written. If it says, so I view force majeure clauses as having two parts. The first part is the triggering event, an act of God, an act of terrorism, some other event, that usually there's a recitation of the various events, and then it'll say, or any other, unforeseen event beyond the control of the parties, some catch-all phrase. Certainly the pandemic is no longer an unforeseen event for a new contract that you're entering into now. However, if the word pandemic is listed there and it doesn't require that it be unforeseen, then that very much could still apply. Now, granted, I don't know how much longer, hopefully not too much longer, that we're going to be dealing with a situation where force majeure is still, a viable argument due to the pandemic, but it's likely going to continue for at least a few months. But if you're signing a contract for a year from now, hopefully it's not going to be much of an issue, but frankly, who knows? None of us thought we would be in this situation anyway. But my point is, if you're negotiating a new contract, a new force majeure clause, try to get pandemic listed itself as one of those triggering events. And then the second part of the clause is, what effect does that triggering event have on the party's ability to perform? And what you want to do is try to broaden the language so it doesn't just say impossible or illegal, but that it also says inadvisable or commercially impractical. Generally speaking, a hotel is more likely to agree to commercially impractical than inadvisable. But if you can get one of those two phrases in there, it very much opens up, it widens the applicability of the force majeure clause and makes it a lot less narrow. But you're going to get a lot of pushback. There's no question about it. I mean, 85% at least of all the force majeure clauses we reviewed in the last year say impossible or illegal, and that's it. And that was pre-pandemic. Now the hotels are obviously much more attuned to these issues, so it's going to be harder. How do you handle a hotel contract where the group says half of the attendees are based in a location that has travel bans, but the hotel itself is in a location that has no group restrictions, a la Florida? Yeah, Florida's been, by the way, the hardest state that we've had to deal with. The hotels are very emboldened by their governor there, who believes that COVID doesn't really exist in Florida. And so there are no restrictions on meetings in Florida. And it's made it really difficult to get hotels to agree to force majeure termination. So what we're dealing with here, and you guys, I know you're based in New England, but you may well, like a lot of associations might be based in some place, but you hold meetings in others. So presumably a number of you have meetings all across the country. So this is an issue that factors into force majeure that we've dealt with a lot. And that is, let's say it's not illegal it's not illegal to hold your meeting. Say it's somewhere in Florida and there's no restrictions there, except, some of and some places in Florida, there are occupancy limitations, like you can only have 50% occupancy. But there's no limitations in terms of, like, you can't have a gathering of 100 people or more. Those things don't exist, but they will say, whatever the typical occupancy for this hotel, you can only have 50% of that in there, and you have to have proper social distancing. So there are some mandates like that. But the question is on the impossibility. If you have a situation where let's say a majority or hopefully even a vast majority of your members are unable to attend because they're subject to employer imposed travel bans. Because here the question talks about travel bans, I think suggesting that it's governmental. I'm not aware of any governmental travel bans from any state or city that says that you can't travel to another city. There are mandatory self-quarantine rules. There are mandatory testing rules. You know, if you go to another state, you're supposed to get tested when you come back. Some states say you have to self-quarantine for 14 days, but there's no bans that I'm aware of, certainly not at the federal level, and I'm not aware of any state or local ones. So any bans are going to come from employers. So if you happen to be representing an industry or profession where the vast majority of employers are prohibiting their employees from traveling, we have used that as leverage and arguments in our force majeure termination letters. But you have to really be able to establish through like a survey or something like that, that a vast majority of your members are subject to or likely going to be subject to continuing travel bans at that particular time. But it's difficult. Frankly, there's not a lot of associations that fit into that boat. And in addition, the hotel lawyers have been rejecting that argument as well. They just don't buy it as factoring into impossibility. Okay. I think that is all the questions about meeting contracts. All right, so let's talk about, there's a number of questions about in-person meetings. In-person meetings are already happening. I actually spoke at and attended one in Savannah, Georgia in late August. That was very successful, very carefully managed with all sorts of proper cleaning and health and safety protocols and social distancing and mask wearing, and no one got sick, and very successful conference. Also involved liability waivers that someone asked here about for attendees, which I actually drafted for them. It's possible to hold in-person meetings. I know one of your attendees on today's program has attended quite a number and has seen them be done very successfully. In the coming months, we are going to see more and more. We already have a lot of clients who are already talking to me and us about, they're planning to do an in-person meeting in April or in May or in June, and kind of planning the proper protocols and everything else. If you're going to hold an in-person meeting, should you require your attendees to sign some sort of liability waiver that says if they contract COVID at your meeting, they won't hold you responsible? Absolutely. It's a no-brainer. You should absolutely do that. And you should couple it with kind of a conduct prohibitions, basically. So yes, I agree to not hold you liable if I contract the virus. I recognize it's a risky situation that you don't have control over, et cetera, et cetera. But then the second part of the liability waiver should talk about, and I agree to abide by all of your protocols, proper social distancing, mask wearing. If I'm, if I don't feel or I'm sick, I won't attend the conference. I won't go off site and engage in risky activities like hanging out at crowded bars and other things like that. All of those things you want to couple in there as well. And I sent to Andrew to send to all of you guys. I think he's going to put them in the chat, but he's also going to put them on some site that you guys can access for the conference. Links to a whole bunch of articles and presentations of ours on a whole variety of association legal topics, including many on these issues. And one of them is an article all about liability waivers for association meetings, and it contains a model liability waiver. So I would encourage you to take a look at that and feel free to use it. There's also articles on all of these issues that I'm talking about, as well as PowerPoint presentations and a bunch of recorded webinars. So feel free to take a look at those as well. And Karen just posted them. That being said, with liability waivers, they're not an end all be all. They don't necessarily protect you from everything. They get tossed out by courts all of the time for various reasons. And so it's not a substitute for engaging in all of the other proper protocols. The whole idea here, and with in-person meetings in terms of legal issues, the primary legal issues, the liability issues, about your association getting held liable, particularly if someone contracts the virus at your meeting. The key is, and the key question is, was your association negligent in how it went about holding the meeting? Were you negligent in not following widely accepted best practices and protocols for in-person meetings? So how do you determine what those are? Well, they're not contained in any one place. They come from lots of different places. And one of my articles about, it's called like the top 10 Q&A for association meetings or something like that. Take a look at that one. It discusses all of these issues. You basically you start with looking at state and local mandates. It does the state or the city or the county mandate certain protocols in terms of how you hold in-person meetings, and quite a number do. So you always start with what is the law that is mandatory for us, and making sure you follow those things. There are no federal mandates, at least to date there have not been. That might change in the future with the new administration. But then you second look to the CDC in particular, which has already, and they've had pretty much since last March or April at least, some very detailed guidance on how to safely hold large meetings in during the pandemic. And so while that's advisory in nature, it's important for you to look at because it helps establish what we call the standard of care, which for civil liability purposes is very much relevant. So you want to follow those protocols to the extent you can. A lot of this is a cost benefit analysis because some of these things can get very expensive. So it's a question of how much can you afford to do, how much can you practically do without making a really unpleasant experience for your attendees. And then another thing you want to do is you want to try to shift as many of these obligations onto the hotel as you can, or whatever the venue is, to say, look, you agree to do these things. In fact, if you look at the CDC guidance for large gatherings, I'd say more than half the things in there are things that would be directly applicable to the venue, like the hotel, not to the association that's sponsoring the meeting, things like cleaning protocols and things like that. And so you want to get them to agree that they're going to do these things. Most hotels will tell you, oh yeah, we have all the right protocols, corporate sends this stuff down. But when you compare what they actually say they're going to do compared to all of these different CDC recommendations and whatnot, there's a big gap there. So you want to get them to agree to as many things as possible that they will do. And just the fact that you are trying to get them to agree, even if it's not part of a contract, but just an email exchange, that helps to establish that you, the association, are not being negligent in how you're running the meeting. And then you got to do some monitoring and policing on social distancing and mask wearing and reminding people of the rules. All of those things coupled with liability waivers. If you do that, it's going to be very difficult, even if someone did contract the virus at your meeting, for them to hold you liable for that.
I have a question kind of in regards to that in the first one that we talked about. It's often we have, clauses in there about groups that compete with you not being in the hotel at the same time. Mm-hmm. Is there any way to also ensure that if there's another group that's in the hotel at the same time, that they also have liability, or that the hotel agrees to manage other groups? I think it's likely that if we have a good relationship with our members and our attendees, we can get them to follow our rules. But if you're in a big hotel, there's likely to be other groups there at the same time. So I guess where does that fall into the liability question and the hotel's responsibility? It's
a great point. And actually I hadn't even thought about that, but it's an excellent point. And you're right, because as we all well know, those kind of precautions, unless you guys are taking over the whole hotel, it doesn't do you much good. It still does you good because you're going to be in your own meeting rooms and things for the most part. But in the common areas, it doesn't do you a lot of good if you have another conference there and they're not following those protocols. So you answered your question. You want to get the hotel, ideally through a contract or amendment to the contract or something, but at least through an email exchange, to agree to enforce those same rules on any other groups that are gathering at the same time. It's going to be very important to do that without any question. I think there was a question about can we require vaccinations for attendees for conferences or in-person meetings? So this is an evolving issue. It's an issue, actually. I was just editing an article about this that ASAE is going to publish soon about this topic. A lot of the association lawyers like myself are talking about this. And this may evolve depending on, there likely will continue to be guidance from different federal agencies, particularly from the CDC with respect to meetings and conferences, and with respect to workplaces from the EEOC and from the Occupational Safety and Health Administration, OSHA. We're likely going to see more guidance on this. But in the meeting and conference setting, first off, there's not nearly as many protections for attendees legally, like rights that would, for instance, limit your association's ability to mandate vaccines. There's not nearly as many rights for attendees as there are for employees in the workplace. There's many more laws, employment laws that apply in the workplace that don't apply to conferences. Well, they apply to employees at your conferences, like your own staff, but they don't apply to attendees. That being said, well, there's not a lot of laws that protect the rights of attendees when it comes to things like this. There are some legal claims that a creative plaintiff's attorney could gin up, and then you just have the practical issues of, basically if someone has a physical limitation that makes it dangerous for them to get the vaccine. If someone has a religious objection to it, if they have some sort of disability, all of these things are going to exist. We're going to see this. I mean, it's already clear from surveys that there's a certain population of our country that is not going, at least for now, not planning on taking the vaccine for various reasons. What my basic advice so far has been, again, this is all subject to change. We'll have to see how this evolves. But right now, it's a moot point because, most of us, can't get the vaccine even if we wanted to. It's just not available yet. But at some point, that's going to change, hopefully in the coming few months. Once it does become widely available, as long as you provide an alternative option, like a virtual meeting option for someone that doesn't want to get vaccinated, and you're making vaccination a prerequisite for attending in person, as long as they can basically access all of the same content and whatnot virtually, I don't think it's going to be a problem for you to mandate vaccines. This is for your attendees. Again, different rules than in the workplace. I don't think it's going to be a problem, and frankly, we're already seeing large venues like sports venues and concert venues talking about that they are going to mandate, that you have some proof that you can, like show on your phone that you have. There's different apps that they're coming out with that'll, kind of prove that you got vaccinated within a certain period of time. And that's, by the way, there's a temporal element to it as well, because we don't know right now how long the vaccine lasts. I've talked to some doctors about it, and they said, it may be like the flu shot. It only lasts for about a year. So there's going to be a continuing vaccination requirement, and most likely, at least for as long as the pandemic is around. But if you want to require that, right now, my basic thinking is you will be able to, as long as you provide some alternative for those who have a legitimate objection to taking a vaccine. In the workplace, it's a lot trickier because of all these other laws that apply. Now, for associations, the good news is that if you can provide a reasonable alternative, AKA working from home, working remotely, for most association jobs, not all, but for most association jobs, as we've seen for the last close to a year, you can do your jobs just as effectively working remotely as in the office. Now, not every employer likes that. A lot of employers, a lot of managers don't like the fact that their employees are not in the office. And as soon as they get the opportunity to, they want to bring people back to the office. But again, at least for now, I'll have to see what kind of additional guidance comes out from the EEOC and OSHA. But for right now, it would be very dangerous, in my opinion, to say, for instance, you can't work for us unless you get vaccinated. And you can't work for us unless you come in the office, and you can't come in the office unless you get vaccinated. That would be a dangerous thing to do. You need to provide a reasonable alternative for those that have some legitimate health or religious or other reason that might be protected by law to not get vaccinated. But it's going to get trickier for someone whose job really does require either being in the office or being on the road and doing travel and meeting people in person, and it's a job that you really can't do virtually. That's where it's going to get a little bit trickier to analyze. If staff in long-term care refuse to take the COVID vaccine, can they be required to wear a PPE well after others are vaccinated? Yeah, I'm not sure the long-term care part, but I think what you're getting at there is that if someone is not vaccinated and they want to attend your conference, for instance, or they want to come into the office, could you require that they are obligated to a higher standard of certain PPE protection, a certain type of like N95 masks, maybe even face shields, other things, making sure that they have to work in an office, like a closed door office, and they're not allowed to come to any common areas. Yeah, I think that's probably going to be a reasonable requirement. As long as they can still perform the essential functions of their job, that would probably be fine. As long as it's not too daunting of a requirement. You got to be careful in terms of what it is. But yeah, if for instance, people who are vaccinated, you say don't have to wear masks. Again, we're not at that point yet, even where the CDC is saying that, because we don't know. We know that taking the vaccine will prevent you or prevent 95% of people from getting the virus, but we don't know if it prevents transmission of the virus. You could still be a carrier and transmit it to others, which is why they're saying even after you get vaccinated, you still need to wear masks, at least for now. Again, all of that might change in the future once we have more scientific information about all of this stuff. But I think that would be most likely, if it wasn't too burdensome, that would be a reasonable alternative. Okay, lots of good questions. All right, I think I've answered all of the meeting questions for now. Moving on to a different topic. And for those of you who want to know more about this topic called the Paycheck Protection Program, I am doing a program next week. Andrew, what's the date you told me earlier? I think it's
the 27th.
Thank you. You know my calendar better than me. Yes, it's the 27th, next Wednesday at 2:30 p.m. Eastern time. I'm doing a program for the Association Societies Alliance, which is that alliance of all the state and regional societies of association executives like yours, called Paycheck Protection Program 2.0, everything associations need to know. So you guys will all be, as members of the New England Society, invited. You should get an invitation to that if you haven't already. I'm going to be doing an hour or 75-minute program just focused on that. So if you're interested in that, if you're considering applying for a Paycheck Protection Program loan, I would encourage you to take a look at that. But for now, a few things. Well, first off, my colleague and I put together a very comprehensive PowerPoint presentation that is on our site. In fact, I think it's the top publication at the top of the list since they're chronological, that I would encourage you to look at. It's contained in those links that Karen sent out to you guys. Also, I did a webinar last week for the California Society of Association Executives with a banker on this issue. That is in our recorded webinars link that was sent to you as well. The biggest headline out of this is that the new Paycheck Protection Program, what I'm calling kind of version 2.0, the eligibility has now been opened up to 501c6 associations as well as 501c3 organizations. The first round last year opened it up to C3 organizations, but not to 501c6s or any other type of nonprofit. It is now open to C3s and C6s, not any other type, any other category of tax exempt organization, but it is open to C6s. I should say most C6s, except those that engage in significant lobbying activities or political campaign activities. But for most of you guys, you should be eligible when you were not eligible last year. It's a very favorable program because these are what are called forgivable loans, meaning if you qualify for the loan and if you meet the substantiation requirements for forgiveness, the loan will be forgiven and you won't have to pay it back. And it's basically, the loan amount is essentially 2.5 times your average monthly payroll costs. So you can probably do a back of the envelope calculation, at least for those of you in kind of executive positions, to figure out what's our average monthly payroll cost, multiply it by 2.5 times, and that's the amount of the loan that you would be eligible for. You do have to show, you have to certify economic need. Basically, you have to certify that you were adversely impacted economically by the pandemic. It's not, for first-time applicants, it's not a hard and fast test. There's some basic, 2 sentences that you basically have to certify that, yes, we were, materially adversely affected by the pandemic. Most associations are going to be able to say that. Believe it or not, some are not. Some of our clients actually did better last year economically, revenue-wise than they did the year before, but most have been hurting due to the lack of in-person conferences and other things like that. So assuming you can in good faith make that certification, you should be able to qualify for a loan at 2.5 times your average monthly payroll costs, and then you should be able to have it forgiven at the end of that. At the end of the period, you would choose either anywhere between 8 weeks and 24 weeks. That's kind of the covered period, and as long as you keep your employees at a relatively high level without letting significant amount of people go or cutting their pay, then you can have the loan forgiven at the end of that period. Most associations will pick an 8-week period. And then you can have it forgiven at the end of that process. You apply through private banks. You do not apply through the Small Business Administration, even though the SBA is the principal administrator of the program. You apply through your private banks. And there is pretty wide expectation that the money is likely going to run out. It's about $250 billion that was allocated for this in the law that was signed into law at the end of last year. A certain amount, I forget the exact dollar amount, was reserved. I think $30 million or 30 billion or 35 billion was reserved for first-time applicants like C6 organizations. But even still, there's pretty widespread expectation that the money is going to run out. So if you're going to apply, I would do it sooner rather than later. Many associations are already actively or already have submitted their loan applications to their bank. So those are kind of the highlights. Like I said, tune in for the webinar next week if you want to have more details. Take a look at the recorded webinar or the PowerPoint presentation. And of course, feel free to reach out if you have questions. Okay, let's see what else we got. If you received, okay, what about, these are a few PPP questions. What about associations that utilize an association management company don't have direct payroll costs? So this is something that was actually addressed last year in guidance that was jointly put out by the Small Business Administration and the U.S. Treasury Department. They put out 3 different FAQ documents last year, and then they continued to update them. The latest update to the one in particular I'm talking about was in December of last year. And that FAQ was the result, I learned later, from lobbying efforts from the PEO, Professional Employer Organization community, particularly a couple of big trade associations in that space. And what that FAQ basically says is that, yes, an association client, or, they're talking about clients of PEOs, but it's the same basic structural analysis. Even though AMCs are not considered PEOs per se, the basic construct is the same. And what they basically said is, yes, you can qualify even though you don't have direct payroll costs. What you need to do is get from your AMC or your PEO a statement of basically what are your average monthly payroll costs for that, that given time period. And so they should give that to you and tell you the wages and payroll taxes, the employer paid payroll taxes. That's what you need to get from your AMC. And if you do that, then yes, you are able to qualify, even though you don't have direct payroll costs yourself. The other thing to keep in mind, if those of you who might work for or own or run AMCs, there's no double dipping allowed. So whatever wages you're using for purposes of, say, association client X and their PPP loan, you cannot also count those wages for purposes of the AMC's own loan application. So a number of AMCs themselves are going to be submitting what are called second draw loan applications, basically round 2, because they qualified last year and now they're applying for round 2. The FAQ makes clear you cannot double dip the same wages for that purpose. And I'm actually doing a program tomorrow for the AMC Institute on this. And that's going to be, I know, a big topic of discussion tomorrow. Basically AMCs have to make a decision. Well, really, AMCs and their clients have to make a collective decision of basically who's going to apply, because largely you're not going to be able to double dip. They're not both going to be able to apply using the same wages. Now it depends if you have many different association clients and only some are applying for a PPP loan, that might well work without having to double dip, but everyone's circumstances are going to be different. Another question here, if you received an employer retention tax credit in 2020, may you still apply for a PPP loan now? So the answer is yes. So there's this employee retention tax credit that some of you, even C6s, might have taken advantage of last year. It's actually a refundable tax credit. Pretty favorable. Basically, if you retain your employees to a certain percentage, my presentation gets into the details, but in short, if you retain your employees for a certain period of time at a certain high percentage, then you get a tax credit for retaining those employees. Last year, the law, it was part of the CARES Act that you might recall, passed, I think last spring, maybe April, I can't remember. But the CARES Act said that if you if you took advantage of the employer retention tax credit, you were not eligible for a PPP loan, and vice versa. You had to pick one or the other. They have now made clear that is not the case anymore. You can do both, and that it's kind of applied retroactively. So the answer is yes, you may still apply for a PPP loan now, even if you took the employer retention tax credit next year, and even if you take the employer retention tax credit this year. Basically, you can do both this year. Just because you did it last year doesn't mean you can't do it again this year. And if you're otherwise eligible, you can apply for a PPP loan. So I hope that answers, I think that answers both of those questions. All right, guys, we need more questions. I think I've answered all of them that have been posed in the chat box. So give me some more on these, or frankly, any association legal topics that might be top of mind. Or just unmute yourself if you want to pose them verbally. Why are virtual trade shows taxable while live trade shows usually aren't? Great question. Complicated answer. It's about as clear as mud. It's very complicated. And to answer the question, I need to take about 2 minutes to give you a little bit of background on kind of the basic construct here in the federal tax area. So this involves what's called unrelated business income. So most of you probably know tax exempt organizations like C6 associations. Most of your income is exempt from federal and state corporate income tax because it's substantially related to your mission and purposes. But when you engage in certain business activities that are regularly carried on and not substantially related to your mission and your purpose, they can sometimes generate unrelated business income, which is taxable at the flat 21% corporate income tax rate at both the federal and state levels. The most classic form of unrelated business income, or UBI, is advertising income. So for those of you who earn advertising income, you pay UBIT, unrelated business income tax, on that income. There are, however, a number of exceptions to UBIT. One of which has been in the tax code since 1976, when ASAE lobbied for it and was successful in getting it included in the tax code. And that is the exception for what's called qualified convention and trade show revenue. But because of the way that exception was written, and because it was written in 1976, when a virtual trade show did not exist, it's written very literally. I don't think it was a knowing thing, but just that's all that existed at the time. It's written in a way that suggests it only applies to in-person trade show revenue. So the reason that ASAE lobbied for it is the IRS was threatening to, I don't know all the details, but basically threatening to tax exhibitor registration fees as UBI, basically saying it's no different than advertising income. You know, it's kind of the same as advertising, therefore it should be taxable. ASAE was able to get this exception written into the tax code. It's been there ever since. But a few years ago, the IRS came out with a ruling. I forget if it was a technical advice memorandum or revenue ruling, but some kind of guidance that said that while in-person trade shows are eligible for the exemption, virtual trade shows are only eligible for the exemption to the extent that they are going on at around the same time as the in-person show. So if you have an in-person show and you have kind of a related virtual component, say you had a hybrid show or something like that, they said that will qualify for the exemption. But if it's just a standalone virtual trade show that has no in-person component, which many associations undertook in the past year during the pandemic, that is not eligible for the exemption. Now, this was a few years ago. This is pre-pandemic. It's not the most current, but it's not that old. I don't expect the IRS to give any clarifying guidance on this. They typically don't. But what it leaves us with is that there is the potential that if you have a virtual only trade show, that the IRS or even your own auditors might take the position that you are subject to unrelated business income tax on that because of that IRS ruling. What I have suggested to some clients is seeing if you can convert. I've heard from, I'm not an expert in the business aspects of virtual trade shows, but I have heard from some clients that these virtual trade shows are really not, at least the ones that I've heard about, haven't really been super successful, have been kind of not as user-friendly, not nearly as successful as other aspects of virtual conferences. I don't know that for a fact. I've just heard that anecdotally. To the extent that you can try to convert some of that from trade show, virtual trade show exhibits to sponsorships, corporate sponsorships, then you're going to have a much stronger argument. That's another exemption from unrelated business tax for qualified corporate sponsorship payments. That's been in the code since 1995. That is I think a viable strategy if it works from a business perspective. It might not, but if you can try to convert those to sponsorships, that's one way to try to deal with this. But of that income being subject to unrelated business income tax, and while the IRS is only going to take that position if they audit you, that's the only way it can happen. Your auditors who come in and do your annual financial statement audits and who often are preparing your Form 990 for you, they might well flag this issue and insist on that money being treated as taxable unrelated business income. So long answer, but it is something you should be aware of. But another thing to keep in mind, like I've told clients for years, don't let the tax laws be the tail that wags the dog, right? If it makes sense to do a virtual trade show and it's successful and it's making you money, go ahead and do it. And if you pay 21% federal corporate income tax as, unrelated business income tax on it, it's not the end of the world. And then if your state has state corporate income tax, you'd be paying that as well. But better to earn 70 cents on the dollar than 0 cents on the dollar. Don't twist the whole thing around into a sponsorship arrangement or something if that really doesn't work from a business perspective. Do what makes the most sense. But at the same time, if you can do it in a way that minimizes your taxable unrelated business income, you certainly want to. And by the way, someone said to everyone, if you're in Rhode Island, remember that conducting a virtual conference or trade show, you're subject to a software as a service tax. I am not an expert in state and local taxation issues like that, so I can't comment on that, but thank you, Nicholas, for that observation. And we have 5 minutes left. Does anyone have any remaining questions? I'm sure you have to. I've never done one of these where there were no more questions left. Oh, here we go. And it's from Andrew. Thanks, Andrew. What do associations need to keep in mind when it comes to navigating governance procedures virtually? Yeah, I'm guessing you were scrolling down the list of articles in my publications and you saw that one there. I did write an article last year about association governance challenges during the pandemic. I'd encourage you to look at it, not just, even if you're not dealing with some governance challenges during the pandemic, and I'll explain what that means. It's a helpful article to understand and get your arms around kind of the basic governance construct that governs associations, where a lot of people I found have a lot of confusion. I do a lot of speaking and writing and board trainings and other things on these issues, review tons of bylaws. And a lot of association execs don't have a great handle on some of these very complicated governance issues. What I'm getting at here during the pandemic are things like, bylaws that say that, the election of your officers and directors is going to occur at your annual membership meeting, and it refers to kind of the processes for an in-person meeting, and doesn't necessarily contemplate some sort of a virtual meeting or voting, electronically by ballot. How all those things interrelate, what's in your bylaws, what's in your articles of incorporation, what your state nonprofit corporation statute mandates or permits, it all has to work together. So for instance, there's a few every state has a nonprofit corporation statute plus DC. And wherever you are incorporated, that's the state nonprofit corporation statute that you look for guidance on this. So some of them say, you can hold virtual meetings, period. Even if it's not authorized in your bylaws, you can hold virtual meetings of the membership. You got to distinguish membership meetings from board meetings and membership voting from board voting, because they're very different legal constructs. Others say, however, you can only do it if it's authorized in your bylaws. There's a couple of states that say you can only do it if it's authorized in your articles of incorporation. And again, there's sometimes a distinction between having a virtual meeting, like a Zoom meeting, compared to just doing an electronic ballot where people are voting. And so this is a whole different session. I could speak, for an hour on these issues alone, and I have before. But I would encourage you to take a look at that article, and it's a good opportunity to revisit your own governing documents, because what you want to do, not only during the pandemic but moving forward, is you want to make sure you have as much flexibility as possible. Governance and governance rules and procedures should not hamstring your organization. You want to make them as flexible as possible to give you as much flexibility as you can. And so it's a good opportunity to revisit those things, maybe make some proposed amendments to your bylaws and whatnot. And then final question here, what have been the areas of highest risk and liability for associations in recent years? So in the 25, 26 years I've been doing this, the highest area of liability risk for associations has not changed, and it will probably never change. It's employment liability for employment-related decisions, issues, et cetera, employee terminations, discrimination issues, disability accommodations, the whole wide range of federal, state, and local employment issues. That always generates, that's the number one area of lawsuits against associations and other nonprofits, and like I said, always will be. So if you're going to, engage in kind of legal risk management and risk mitigation, you certainly want to look to those things first. Make sure you're all buttoned up with your employee handbook and your policies and procedures. Make sure everything's consistent with the most current federal, state, and local laws. These laws change all of the time. In fact, we're gonna without question see changes at the federal level, both in terms of rules and regulations as well as legislation, most likely, with respect to federal employment laws in the new administration, and they change all the time at the state level. So you want to work with an employment lawyer that in your state that's really knowledgeable about those things. But then it's not just the policies and procedures, it's about how you go about doing things. So I counsel a lot of associations on employee terminations and employee discipline and things like that. Can give rise to very significant liability risks if you don't do things right. And if you do things right, you want to get good counsel on this and things like that, it can really go a long way toward mitigating your liability risk. And finally, you want to be sure you have good insurance. Makes all the difference in the world. While the insurance, I did a program for ASAE a few weeks ago about kind of insurance during the pandemic. It was focused in part on event cancellation insurance, but also in part on other types of insurance. One of the big takeaways from that program, from the insurance folks on the call, is that insurance premiums are going up significantly, in part because of the pandemic, but in part because of other structural changes that have been going on. And I'm seeing more and more insurance carriers that are dropping associations after they file a claim because the market has gotten so difficult. It's a consideration you have to keep in mind. In the past, you got hit with a small claim, an EEOC complaint, or at the state level, from a disgruntled employee or someone you terminated, and you would notify your D&O insurance carrier, which is where the employment practices coverage generally lies, and file a claim and let them defend it, less your deductible. Well, now I'm advising some clients for a smaller claim, it's not worth it. You might get dropped by your carrier, and then if you can find other coverage, it's going to be a lot more expensive. You might be better off just settling the case, paying, if it's a relatively strong case, paying some legal fees to try to get it dismissed, or whatever the case may be, but that has to factor into your considerations. I know we're out of time. There was one other question here. I was advised by my counsel to document. He told me there are board inspectors, board BORED, in our respective state, Secretary of State and Attorney General's offices reviewing financial transactions and annual reports from nonprofits. Already heard of a couple association execs that have been conducted for an audit of meeting minutes and accessing operating account statements. Yeah, documentation of what you are doing right is very important. It can be very prophylactic toward protecting yourselves. For instance, on the employment setting, and this is not what this question was about. This question is more about corporate issues like Secretary of State's office. But on the employment front, when you have a problem employee and you think you're going to have to let them go, documenting the poor performance, informing them of the poor performance, giving them a chance to improve, that is the most critical thing, so that when you're ready to pull the trigger and let that employee go, it becomes almost impossible for them to bring a discrimination claim or something like that, because you've documented the performance and the communication with them and whatnot. So yeah, I couldn't agree more, but you want to document that you're doing things right. Just documenting what you're doing doesn't necessarily by itself do a lot of good. So Andrew, it's 4:46. I'm going to wrap things up and turn it back over to you.